Hey guys, welcome to another Corona Geek. We're here with Chris Reid. Chris is an intellectual property lawyer specializing in indie game development. He's going to talk to us today about some of the things that we should be thinking about. And also we have some questions from the community. So Chris, I just want to thank you for taking the time to talk with us.
Absolutely. Happy to be here.
Excellent. So now tell me, I could probably read right from the website, but you give us your background. Just tell us who you are and your experience.
Sure. Yeah. Don't read from my website. It's terrible. Needs a redesign. But so I'm a solo practitioner. I work primarily in the game community, though I have a lot of clients who are just non-game app developers, small tech companies, that sort of thing, mostly in the creative space, but some of them are just sort of generally tech. I used to work in patent litigation at a large firm in Manhattan. It's about as exciting as it sounds. And I've always been a gamer my whole life since the Apple IIe. And I really wanted to get into the game industry. And I realized a couple years back in 2012, I started to look around and realized there was a huge boom in indie development. And there was not a corresponding supply of affordable and directed legal advice. That there were a lot of these really talented developers, and they had no idea on the legal front. They sort of knew there was something they should be thinking about, but their only options were big firms who weren't really specialized in the game industry and were, besides, way too expensive and not really designed to help individuals or small companies. So, I set out to start serving that community with the side benefit of getting to hang out with developers, which I think is pretty cool.
I can totally relate to that. I love talking with smart people.
Yeah, I surround myself with people who are smarter than me, or at least smarter in the ways that I think are cool.
Excellent. Well, here, I've got a bunch of questions from the community, a handful at least. And then I know that you had some trends and things that developers should be thinking about. So let's just dive into those and see what comes out of it. So the first question from the community is Raphael asks, he says, what's the best way to protect your game from game idea or intellectual property from clones that hit the App Store? And is there something you can do beforehand or something that you can do after?
Sure. So that's a very broad question. And it has a not so satisfying answer and some somewhat satisfying answers. Let me first say, before we start diving into answering specific questions and me sort of giving some thoughts, I am required to give the standard disclaimer as an attorney. It's a real disclaimer, which is that this is not legal advice. I don't know anything about your specific scenarios. It's not creating an attorney-client relationship. Don't run out and act on it and think this is the be-all and end-all. But I'm happy to answer questions about general hypotheticals and give sort of some direction. And I hope it's helpful as sort of a starting point. But a lot of these, the answer is going to be, here's sort of what you need to know, but it's very complicated. And in this scenario, you probably need to talk to a professional. So I just wanted to give that disclaimer up front. But to move into the question, so the first thing to understand is that the idea behind a product or a game or an app, the core idea is not necessarily protectable by intellectual property. But portions of it may be. It's possible for software or business methods to be protectable by patent. But I'm not going to go into that because, to be perfectly honest, for small developers, it's almost never the right move to be going after a patent. I mean, if you have $20,000, $30,000 in your pocket and you want to spend 2 years getting it and it still maybe doesn't protect what you think it does, it makes sense in certain contexts, but often is not the case. So that's patent. Under copyright, which is a separate type of intellectual property, a lot of things are protectable, but abstract ideas are not. And the problem is that the cool idea that you had in the shower that is the inspiration for the game or the app is the very thing that you can't protect on its own. What you can protect are all the things that you set down in a fixed medium, meaning the actual code as written, the art assets, the UI. If it's a game, and say it's a narrative game, all the dialogue, all the motion capture, voice acting, the sound, all of those things are protectable by copyright. So all the pieces that go into making the game are protectable, but the core idea, and I keep using games, but there was recently just a case that reaffirmed this, but the mechanics, for instance, the rules of your game, not protectable. So Candy Crush, right? There are a million match 3 games that are basically Candy Crush. they can't protect the idea of match 3 game. But if you made one that used the exact same colors, the exact same icons, everything structured exactly the same, then you start to get to a point where you have a really close copy versus a clone. So that's the bad news, which is that a lot of times if someone reskins your game and it's effectively the same features and the same mechanics, but all that it's arranged slightly differently and all the graphics and the sounds are different, they haven't really infringed your copyright probably. So the question is, what can you do? It depends on how close it is. So if it's a really close copy and a lot of the graphics are very similar, then you do potentially have a copyright case. Practically speaking, copyright cases are very expensive. So what you're talking about really is trying to assert your rights while really knowing that you're not probably going to end up in federal court, because that's very expensive, tens of thousands of dollars, and you're not guaranteed to win. So a couple of things you can do. On the copyright front, which is, again, the copyright is your content, right? The artistic stuff. And I make that distinction because we're going to talk about trademark, which gets confused with it. But the copyright content, you can send, the couple of things you can do. You can send a cease and desist letter, either on your own or with the help of an attorney, which, usually I call like a nastygram, although they don't have to be nasty. I would say from my experience, depending on who is doing the infringing, you may want to consider sort of the nice, friendly, hey, we're all in this together, but my lawyer said I have to send this, etc. If it's some company that's clearly just into cloning things quickly, making bucks for a week and then going away, then yeah, be nasty. So that's one thing. You can also send what's called a DMCA takedown notice, which sometimes has a bad reputation because they can be used on either side by anyone. But basically it says it's a formalized method, and Apple, Google, Steam, all the big distributors, YouTube, they have procedures for this. And but basically it's a form letter that says, I am the copyright holder. You, content hoster, are hosting something that includes my protected copyrighted material, and I didn't authorize it. Please take it down immediately. And I am, signing an affidavit that says I really am the holder. They'll take it down. Then you start a process of proving it, and the other person can say, oh, no, we actually think they're not the holder and whatever. If it's someone who's basically just trying to rip you off, they'll probably just go away. That can end up being a game of whack-a-mole, which is why ultimately there isn't a silver bullet, and I'm sorry. There's no magical way to just the secret code you put in and all the infringers go away. But that's sort of the more practical thing you can do. And you threaten going to court, but chances are, unless a huge amount of money is involved, if your app's making $1 million a year, yeah, absolutely, it's worth going to court. But if it's not, then the costs of enforcing your rights may be more than what you're going to get back. One last little bit on the copyright thing. If you think you may need to threaten or end up going to court, you should go and register your copyright. You do not have to register your copyright with the Copyright Office in order to own it. It's not compulsory. The fact that you coded it, that you saved it, that you created it, that means that you own the copyright by default under US copyright law. But if you register it, and it's very simple, it's I think $65. There's a form. You can either have an attorney help you, or you can probably figure it out, through their site. You want to do that once you release it, or at least before you sue someone, because it gives you basically some extra benefits if you end up in court. It lets you sue for more money. It gives you presumptions in your favor, and all that translates into a scarier letter that makes it more likely that they're going to get scared and stop infringing. That's what you can do, basically. If the problem is not as much that they're copying the game, but they're using a similar name or a similar icon, then you're talking about trademark infringement.
Okay.
Most of the practical things are the same for that. A letter, or it's not a DMCA takedown, but Apple, all of them, they have similar procedures. So again, email or contact the people hosting it, and then try and contact the people doing the infringing.
Well, let's talk about that for a moment, because I'm going to jump to this next question, which was we were going to come to later. But since you're kind of right there anyway, let's go ahead and talk about it. Adi says, "What do you do when an overzealous lawyer sends you via Google or Apple a removal notice since your app is using your freshly received trademark? What's allowed and what's not allowed to be used?"
Sure. Again, a very broad question. So I'm gonna try and answer it broadly and give a few examples.
So
I was
so
going to
so
get
so
overzealous,
so
but
so you just said, hey, if I have received a trademark on something, I should send out a letter to somebody letting them know, right?
well, okay. So a couple of things. I think first, let's start with what it is that trademark law protects, right? So when someone, because the letter may not be overzealous, right? It really depends. If they do have, look, it's never going to feel good to get one of those letters, right? I'm not saying like you should be happy. Of course, they're not fun to receive. But there is a difference. I have seen totally justified ones where I've said to my client, look, probably should have Googled before you chose that name. And unfortunately, this sucks, but unfortunately they've got a decent case and it's not worth fighting on this because you probably lose. And I've seen ones where I look at it and I say, okay, you make a game and they do locksmithing services for roadside assistance. This is like probably computer generated, or they looked at it for 3 seconds and just spam it out to everyone who has the word lock in their name. And that's, we can ignore this. There's a big spectrum. So trademark law, which is different than, it's separate from copyright law. Copyright, think of it as your content, the art, the code, the dialogue, sound, the UI, all that stuff that you can see and hear and perform. Trademark is all about the brand. And so trademark law all comes out of this idea of protecting consumers from being confused. So that's why it covers like taglines, logos, and names. And so in trademark law, you can have trademark rights even if you haven't registered. When people talk about trademarking something, usually what they're referring to is filing, and I'm speaking of US law here, by the way. They're speaking, but most countries have an equivalent process. The EU has it, Canada. And when they talk about trademarking something, they mean filing with the Patent and Trademark Office an application that says, we would like you to recognize that we have trademark protection in this term for these goods or services. You do have rights that come about even before you've done that if you start selling things. So as soon as I use a name to sell stuff, I start to accrue trademark rights. They're called common law rights. Those are based on state laws. They're harder to prove. They're not as broad. You have to go and show, okay, my tattoo parlor's been open on this street for the last 12 years. Here's a picture when we opened, here's the date, and here's how broadly our customer base is. That's a lot harder than saying, here, the PTO granted our trademark application. When you have that, it gives you a couple of benefits over the common law stuff, which is that it means your trademark applies equally strongly across all 50 states, regardless of where you're based. It gives you some positive presumptions if you end up in court. Basically, they start from the assumption that your trademark's valid and the other people have to prove that it isn't, which is helpful. And most importantly, it lets you call dibs in advance. I said before that you get your rights when you start selling something. They call that use in commerce. So you have to actually be selling something with the name to get the rights. This is an exception. You can basically apply and say, we intend, in good faith, we intend to use this soon. Like, for instance, for software, we're in development. We know the name. It's going to be done in a year, but we want to get the name locked down now. Perfect example. People do that all the time. You can't call dibs forever. There's a maximum of 3 years. You have to do it in 6-month increments. It requires filing something on time. So all of that to say that if someone sends you the letter, you want to do a couple of things. First, you want to check and make sure that what they're telling you is valid, right? So it could be BS. And the way to tell if you've got a real problem is, one, go and check, first of all, see if they're just saying we have trademark rights or if they're saying we have a registered trademark. If they're just saying they have trademark rights, it's going to be in the form of something like, we've been using this name to sell this software since 2007. Okay, go and do some Googling, make sure that they really have been selling it since then, right? If they're claiming that you're infringing a registered trademark, there's a couple of simple things you can do. You can go on the PTO website, the Patent and Trademark Office, uspto.gov, and they have you can do Boolean searches. There's a lot of things, but for a non-lawyer, you can go in and just search the actual name. Make sure that their trademark exists and that it's live, meaning it hasn't been abandoned. And then here's the other thing. You don't just trademark a word. A lot of times people have this idea that someone grabbed a word. It's like, oh, they just bought that word in the English language. That's ridiculous. Well, Not really. Usually the trademark isn't a single word. It's, whatever, maybe there's like a kennel called the Dog Whisperers or something. They didn't trademark the name dog. They trademarked specifically that phrase, the Dog Whisperers. And when they trademarked, or when they filed their application, they had to say what classes of goods and services it was for. And so there are 40 something international classes that they kind of split everything, every good and service that you can imagine falls into one of these, right? For purposes of this podcast, probably class 9, which is software, and all sorts of other stuff like nautical instruments and scientific instruments. Yeah, they designed these long before software was a big thing. So if someone has something that's the same name as your app, but it's like a toilet paper company or dog toys, that's not nearly as much of an issue as if it's in class 9 and it's for software. And even if it's in the same class, it may not, there's all these other things. So there's the class, and then within that, there'll be some language. There'll just a list of a whole bunch of things that will basically be they're describing the goods and services. And it could be that it's for scientific instruments, right? And your thing is a game. Okay, they're technically the same class because these classes are really broad, but you might be able to look at that and say, you know what, these aren't really the same. And the reason that works is that trademark is not about, did you copy my stuff? It's about, will consumers get confused looking at these two names and think they're from the same company? So that's the argument you'd make. So first, make sure that they're not full of crap. If they're not full of crap, then you may be in trouble. You have to decide, is it worth fighting over it, right? Is it worth splitting hairs and trying to make an argument, and saying, we don't think so, and we're not going to change our name? Or can you just say, you know what, we'll design a new logo and change the name and move on? That's what you do in response to it. Ahead of time, again, do that search on the PTO site and do the Googling. It doesn't take long. It's free. If you're really concerned, you can pay firms or an attorney to go through and do like an extensive thing. Whenever I do trademarks for clients as part of the package, I always will do a search ahead of time, and that's to lower the chances that there's a problem, right? Giant companies are not immune from this. Perfect example for gamers out there: Blizzard just released a game called Overwatch. They paid a lot of money because their trademark attorney made a mistake, which is didn't do a simple Google search to realize there was already a fairly large game out there called Overwatch. Well, they'd already committed to everything. They wanted the name, and they had to basically settle and probably pay these people a huge amount for the rights. That could have been avoided with a simple search. So that's sort of the preemptive stuff you do. So that's kind of my answer. It's not always a BS thing. And don't get too attached to the name. Sometimes people spend a lot of tears and a lot of effort and a lot of money when they could just change the name and move on.
Yeah, and I totally agree. It never feels good to get a cease and desist letter. I've received them a number of times, and it's just not a good feeling, and you feel a little bit helpless, and you have to figure out what to do. One of the things I thought that you said it was interesting there was. And I don't want to put words in your mouth, so just tell me if I'm wrong in this. Ignore a notice. Can you just ignore a notice? What happens then?
So it's funny you say that, because I was about to follow up with something on this line, which is a cease and desist letter is just that. It's a letter. A lawyer drafted it and sent it, and the purpose is to get you to stop, to get you to do something. There isn't any legal force behind the letter as a letter, right? It's basically a way, and I don't want people to misinterpret this, because it's totally valid to basically scare someone into doing what you want them to do, assuming that what you're telling them is true, right? So for instance, if someone releases an app with the same name as my app that I've been selling for 3 years, or a very similar name, and it's a similar app, and I've registered a trademark, and I've put a lot of money into developing it, I absolutely should be defending it. And side note, with trademark, you actually do have to enforce and try and go after people in order to keep the trademark rights strong. Not the case with copyright. So I'm justified in doing that. When I send the letter, what I'm hoping to do is to get them to stop or change their name for the least effort possible. Sending a letter is very simple compared to filing a lawsuit. So that's why it's always the first step. And usually it says, we noticed you were using this name. We have the rights. Here's some proof. Maybe we attach the registration. Please stop by X date, or we'll have to do more. And they hope that the person getting that letter says, oh, I don't want to deal with that, and stops. And it's funny because when I phrase it that way, I think most people are thinking, oh, I won't get taken in by that. Well, sometimes you should be stopping, right? Because if, like we said before, if they have a good case, then you might have just messed up and not noticed that there was a big app out there already that used that name. But if you think it's spurious or you want to fight it out because you think there's a distinction and you really attach to the name, yeah, you can either ignore the letter or what's better, respond to the letter. And I've had clients hire me to do this, to write back and kind of say, we received your letter, and then explain the various reasons why, from your perspective, you're not doing anything wrong and that you don't intend to change it because XYZ reasons in trademark. And, I like to use the phrase, as I'm sure you're aware, which is a little douchey, but it's the way of saying essentially your letter's BS, you don't understand trademark law, we're fine, we don't have no intention of changing it. That's calling their bluff essentially. Because the next thing they have to do is, well, if you do that, then they kind of have to take action. Or not, but they're the ones who have to spend the money to institute the case, right? Now, if they want to go to court, there are other things they can do. We talked about them in the first question, right? They can go, and I think that's what this question was premised on, the idea of them contacting Google or Apple. That's a hassle. So in court, the onus is on them to try and stop you and to pay the money to start the court case. But in the practical world of the App Store or Android Marketplace, Google or Apple is just going to take it down. Or they're going to contact you and say, we received a complaint about this. Please work it out in the next week or two, or we're going to take it down. And that can be hugely disruptive. Even if you're taking, especially if it's at the wrong time, right? You just launched, you're having this huge success, and you get the takedown notice. If it's disrupted for a couple of days, you've lost your momentum. So it's worth responding to these things if you think you have something to lose, and it's worth figuring out how strong your position is. So that's what I'd say. And so the bottom line is, it really depends on whether or not they have a good case.
Okay, and that sounds fair enough. And it also sounds like it's very important as to whether or not there's money on the line, right? If you can't afford to fight the thing, then maybe make your decision based on that.
Right. Yeah. This is a common theme with a lot of my advice, which is that a lot of times people write articles and talk about the law from the perspective really of like giant companies and I like this too. I'm a nerd. I love thinking about the cases and, how can we win this case? And it's like, those technicalities are cool, but a lot of times to get to that argument and to have that cool, interesting discussion, you have to be in court. You have to have tens, if not hundreds of thousands of dollars to be able to have this giant litigation and have that cool conversation. This comes up a lot with fair use that people love to ask questions about. They love to think they know everything about fair use. Turns out you don't get to make your fair use argument unless you're already in court, and that's expensive. So that's my line on that.
Okay.
I can answer more questions about it if people really want to know, but the bottom line is 90% of the time it's probably not fair use.
Right.
Even if it is, if they have more money than you, they can say, we don't think so, let's go to court. And you'll say, oops, I can't afford that.
Well, let's move on here. We've got a question here from Dave. He says, if you're selling a game under your iTunes individual account as a sole proprietor, do you need a DBA to show another name as the maker? And his example, he says, can I release a game and then on the splash screen show a business name, even though I don't have an LLC or DBA by that name?
Sure. So that's a question. That's just an Apple policy question. And I did a little bit of digging ahead of this podcast just to confirm what I thought. But Apple's policy, and I think one of the other people in the chat had said that Google's is different, but Apple's policy is that you cannot, so there's two things. The splash screen is one thing, that's within your app. The actual page where you're selling it is a different thing, who's listed as the developer, right? And for Apple, I take it that you can either join their developer program as an individual, in which case they require you to use your legal name, or as an entity, as an organization. If you join as an organization, you can't use your DBA or a fictitious name. They need you to use your actual company name. So if you want to use a company name, you need to actually have an entity. And what that means is an LLC or a corporation. And you would be entering into the contract with Apple as that corporation or as that LLC, not as yourself individually. And that has various implications for liability because the entity that's signing is the one who's on the hook. And the whole point, one of the main points of a company, an LLC or a corporation, is to provide a liability shield. It's just the company that's at risk, not your personal assets if something goes horribly wrong. Yeah, I think that's a fairly straightforward one. You can go and look if you search on Apple's website. They kind of lay that out in their policy about their.
But is it fair then to say that you could put something on your splash screen, but not necessarily the developer page? Is that what we're saying?
I believe so. I mean, the splash screen, that's within the app, right? So that's just whatever you want to say, right? You can call yourself whatever you want inside the app, but Apple will not let you, as far as Apple is concerned, and as far as me, as a consumer going on in the App Store, I will see if you signed up as an individual, you'll have to use your personal name, and I will see your name as the developer. Once I launch the app, it might say whatever, whatever the name of your company is. That's fine with your logo. That's great. But Apple. That's a question of Apple's policy, and apparently they don't allow you to do that.
Okay. And from my own personal experience, as you say, if you're not looking for a liability shield or whatnot, a DBA is, from my experience, again, has been fairly simple to get, just because
that varies by state. So a DBA or fictitious name is something that each state has different rules on. Usually there's some paperwork that you have to file. You just have to find a name that isn't taken. It may involve getting a business license of some sort. Most states, that information is pretty easy to find on their Secretary of State website. So again, Google is your friend here. It's not an arcane procedure, right? They want people to be able to do it fairly easily. So, and there are also, I should note again that there are tax implications to having a corporation or an LLC or being a sole proprietor. Ask your accountant, and if you don't have an accountant, get an accountant. I don't give any kind of tax advice because that's not, other than the very top level, these are the differences between them. I'm not a tax advisor. So.
Okay. Well, there you go. So one of our questions was from Dan. So Dan asked a question related to tax. So Dan, there you go. You had to go ask your accountant.
Yeah, sorry about that. And since it was an international question, I would say not only don't ask just a generic accountant, make sure that they either know about the about international tax laws or the laws of that specific country, or that they can look it up or know someone who knows it.
Yeah, and just for the audience who's listening, so they'll know what we're talking about. Dan asked, when dealing with outsourced development, how should I handle taxes? For example, I pay $1,000 to a developer in the EU to create an app, and I'm based in the US. How do I handle this from a tax perspective? So yeah, that's definitely a mixed bag.
Yeah, what I would say, one thing I would say as a general matter is in the contract that you have with them, and yes, you should have a contract. I cannot repeat that often enough. If you are working with someone, hiring them, going into business with them, being hired by them, you must have a contract before you start working. I know this doesn't always happen, but if it hasn't happened, get a contract in place, retcon it, but make it happen. It's the number one problem that people run into, and they think it's fine, and until it's not. So in that contract that you definitely have with this person that you're hiring and who's in, like Romania doing coding for you, you can probably put stuff in the payment section that basically says like, contractor is responsible for doing all their own taxes and following all their local laws, essentially. So that way you're sort of saying, look, I'm just wiring you the money, and you are warranting to me that you're going to follow tax laws and that I'm not responsible for any of that. I would still talk to an accountant and make sure that's the sort of thing that you can disclaim. There may be some specific, there may be some things in the law that don't let you get off the hook for that, no matter what you put in the contract, that are specific to the tax code. So just be careful.
Okay. So along those lines, Jason asked the question, any suggested template contracts or boilerplate language to use for client work?
Oh, yes, I have many. So this is probably one of the most common things I do for clients, either putting together so I think what they are asking is, and I guess correct me if I'm wrong, but I think what they're asking is, if I, a developer, am being hired by someone else to develop for them, what should I put in the contract I sign to protect myself? It also can go the other way. If you are a developer and need to hire additional hands to do UI, to do more coding, whatever, you should also have a contractor agreement to hire them that should protect you as the company or as the person hiring. So some of these apply to both, but I'll answer that question directly. So client work, I assume, means hiring yourself out to a client for whom you are developing. So in no particular order, and there are more things, but basically I'd have to just walk people through a full contract. Things that are very important and that should be addressed in this agreement. So first off, have the agreement. Negotiate it, talk about it, get all the deal points together and write it and sign it before you do the work, before you do any work. That is my very strong suggestion. It's not always the case, but even if you've started, fine. Say, you know what, before I go any further, I need to get this signed, right? The more you work without the contract, the more risk you take on that all that work, that the person flakes out and now you don't have a written contract. So it's this whole fight to get paid and it's not clear exactly what the terms are. And that's just a nightmare. It's much better to do this up front. So some of the terms that should be in this contract. First off, you want to think about the term, by which I mean, how long does it last? When does it start? How long does it last? And connected to that are going to be termination provisions, meaning how do I get out of this thing? How does each party get out of it? So, can each party terminate for breach, meaning I didn't get paid and it's been 30 days, so now I'm out, I don't have to do any more? Are there scenarios where you're allowed to just leave? Are there scenarios where your client is allowed to say, you know what, I canceled the project? That's usually called termination for convenience, meaning, and that, they may ask for that. If they ask for that, that can be a real hassle. If you've stopped taking work, you don't have anything in the pipeline, you thought you'd be working on this for the next 4 months, they cancel it a month in. That is why, connected to that right, if they have it, you want to ask for a kill fee. Meaning, sure, you can decide that you're not going to make the app anymore, you ran out of funding. But if you do that and you cancel before we're done, I get paid the following kill fee to make up for the fact that I didn't have anything in the pipeline. And that can be different things. It could be a specific amount. It could be all of the next milestone. It could be whatever, half of whatever's not finished yet. So I think that's a prudent protection. Speaking of payments, that's the next topic. I mentioned milestones. Depending on what you're doing, you could be doing it hourly, but assuming that the idea is that you're making a full app for someone who doesn't really know about software development, they've got an idea, you're doing the development for them. When you describe, you want to have a document attached that has, something called like a statement of work or a schedule of work. It can be called whatever you want, but a document that lays out the technical specifications, that lays out the specifics of what you're making, what the features will be, in reasonable detail. Obviously, it's an iterative process that's going to change, but the key here is that you want in writing what the rough scope of the project is. And that should be broken down into milestones. So as you get paid, you don't want to say, I get my full payment at the end. You definitely want to ask for some amount up front. Half would be great. That's to protect you in case they flake out, because then it's always better to have money in your pocket and have them have to ask you for it back than for you to get, let go and then have to come after them for the money. That is a huge hassle. So having some up front mitigates your risk. The rest of it, you want to break the development into milestones, first vertical slice, first playable alpha, beta, and then gold master, however you want to split it up. And you get paid at each of those things when they accept those milestones. That's a prudent way to set it up. That way, you're getting paid as you go, and you're never really behind if they flake out. So the kill fee could be set up as, I get all of the next milestone as my, compensation for you bailing out. So that's all the compensation stuff in very general terms. I think those are important. A couple other things. I mentioned that you can see all this stuff is kind of connected. I mentioned the scope of work that we want to have. You want to define roughly what the scope of the project is. That's important because you should also have a section that prevents what I like to call scope creep, which is just the worst thing ever. And it comes up a lot when you're doing client work, especially for people who've never handled software development before. So someone who's like, I've got a great idea for an app. Will you make it for me? Okay, great. They do not understand how software development works. They think it's like painting a picture. Oh, well, it's going to take you 20 hours. they say, hey, make that a little more blue, as if that will take 3 minutes and it won't require you to rebuild an entire section and 3 more weeks of work. So, and it can be honest, but you can die this death of 1,000 cuts where the project was a flat fee, $40,000. Then as you get into it, they start saying, oh, can you change this? And would you tweak that and do this? And could we replace this? Now that I see it, I don't really like it. And suddenly you're doing twice as much work and the flat fee is the same. That becomes a really bad deal quickly. So if you've defined what the scope is and roughly what the features are, the maximum fee, whatever, Twitter integration, or if it's a game, right? Like 7 unique character models and 12 levels and, the blah, 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 blah. That way, if they ask for more, you put a piece in the contract, and these usually aren't in there by default. I always add them when people have me review, that says, if you ask for a change, and I deem it to be a material increase in scope, so if it's going to increase the scope of this work by, pick a number, at 5%, whatever, 10%, then I'm entitled to send you a quote that says, this is going to increase the scope. It's going to cost this many more dollars. Do you want me to do it? And you don't have to do that extra work unless they agree to the extra money. That's called a change order. That's a great protection to stop you from getting screwed by the client that kind of gives you death by 1,000 revisions. So I think that's one of my kind of pro tips to definitely throw in there. I always put them in when I'm drafting contracts from this perspective. Let's see. Speaking of the content and what you're creating, I think it's also important to have a clear approval process. So we talked about going through and having milestones, right? You want to have somewhere in the contract a little rule book that basically says, look, when I hand you the first vertical slice, or I hand you, some milestone, because I get paid when you accept the milestone. Well, what does it mean for you to accept it? I'm going to give it to you. How many days do you have to turn it around? You don't want this to all be blank, because then they could go on, oh, I was on vacation. 3 weeks later, you're just sitting there waiting, not doing any work, not getting paid, right? You want to say, company shall have 5 days to review. Then they're going to tell you if it's accepted or denied. If it's rejected, then they're going to tell you why it's rejected and what you can do to fix it. You have X days to fix it, and then they re-review it. And you might even put a maximum number of times that this can happen to stop infinite revisions. And you want to have a default rule, like if they don't get back to you in 3 days or 5 days, then it's automatically assumed to be accepted and they owe you the money. Because you want to know exactly when you're going to get paid, right? You don't want to be having to kind of constantly call them and do all this. And this stuff absolutely happens. And it's not just because people are like evil and don't want to pay. People always get into this. They could be out of money. They could be doing other things. They could have a different idea of when they have to pay you. Put it all in the contract. There's a rule book. It makes it a lot less of a fight, because you just point to the contract and you're like, you had 5 days, you didn't get back to me, now you owe me, this is clear. In the words of an attorney friend of mine, fuck you, pay me. Very, very excellent attorney, Gabe Levine out in California, I think coined that as part of in a video that made the rounds. But yeah, he's 100% right. You should make sure all these provisions are there to make sure you get paid and that it's clear. And that if they decide not to pay you, you've got a really clear rule book to point at and say, go to hell. You need to pay me right now. It makes it a lot easier. And if they decide to fight you on it and they get a lawyer, their lawyer will look at it and say, you should probably pay them. This is pretty clear. Right? That's the goal, is that they don't have a leg to stand on.
So is that where it starts? Is collecting the money? Is that where it starts? Basically, the two lawyers getting in the room and kind of looking at the contract and saying, "Oh, no, you should pay these guys." I mean, how do you collect your money?
Well, here's the interesting thing about a contract. It shouldn't even get to the point where lawyers need to be involved, or at least two lawyers need to be involved, because the ideal scenario is someone approaches me, I'm a developer, and says, "I want you to develop my app." And the developer says, I listen to the Corona Geeks podcast. I'm forewarned and forearmed with all sorts of useful knowledge. I know that I should have a contract. They hand them a well-drafted contract that has all these protections in it. They talk about it with the other side so that both sides understand what the rules are. And by discussing the contract and negotiating it, now you have a scenario where both sides have actually kind of engaged and thought about it. A lot of times people make a deal and they both have the best intentions, but because they haven't really talked about it, each side has these assumptions that are different than the other side. By the simple act of negotiating a contract tends to bring people's minds a little closer together, which interestingly makes it less likely that there'll be a fight. And if there is a fight, there's a clear contract, there's a clear rule book to go to. And so you can just be like, look, I'm sorry, but you do have to pay me because look at section 5B, you had 5 days, here's the timestamp, I sent you the email 7 days ago, you never replied, so it's deemed accepted. And that should be the end of it, because if they're reasonable, they'll realize, oh yeah, I did agree to that. There's not really a way for me to fudge that. If they're really crazy and they hire a lawyer and it gets to that point, again, having a good contract, that lawyer, if they're a good lawyer and they're not just trying to tell the client what they want to hear, will look at it and say, yeah, you don't really have a leg to stand on here. Let's settle this. So I think all of that is there to help you, to provide protection for both sides, honestly, so that there's clarity, so that you can get paid, so they know what they're getting, and that they have the right to approve stuff, but also that how quickly that's going to happen. A couple of smaller final pieces. Well, one more big topic and then two little bits. The topic of intellectual property, the rights. This is huge, right? So I just talked about the scope of the work, termination, like how you get out of it. So what do you have to do? How do you get out of it? How do you get paid? These are the things we talked about, all very important. And then the last one is who has the rights and when. If you're doing client work, as the person in the chat put it, that probably means that they're hiring you to make an app and they basically want to own the app, right? A couple things that are relevant to software developers. So one, it's fine, probably you're okay with the idea that they own the IP to the app, right? You're making it for them. It's not the app you're making. They hired you, they're paying you. That's what they're paying you for, right? To do the work and hand it off. If they get the app, they can sell it. But a couple caveats. One, as software developers, there's often kind of tools, algorithms, code, stuff that you reuse from project to project. And on a specific project, kind of like the special sauce, right? And that gets developed. I'm not a developer myself, but I talk to enough of them to know that this is the case. From project to project, maybe it's a graphics engine or something, right? And you used it in one piece of client work, and you really, you developed it and you added some cool stuff. And you do another piece of client work and you want to reuse chunks of that engine and develop it further. You don't want the contract that you sign to mean that you can never reuse any of that code at all. So there's a way to create a carve out. And the term that's generally used or that I would use is developer tools, which are kind of like the family jewels, the special sauce. And basically, and I have wording for it that I put in, but it's a way of saying, look, the client owns everything in the final app, but except for the specific stuff that we're going to call developer tools, which are the non-specific algorithms, whatever, code structures, engines, whatever, define what it is that you're likely to have. That stuff is still owned by the developer, and the developer, instead of assigning it to the client, gives them a very broad, a license, a perpetual, fully paid license to use all that stuff only in the context of this app. So basically, from the client's perspective, it's still the same. They walk away with an app that they never have to come back to you for rights. They never have to ask you permission again. They can sell it free and clear. It's all good. But they cannot hand it off to someone else, have them reverse engineer your graphics engine, and then use that in future apps. And they cannot come after you for using your engine in future programs. But they get the assurances that you can't come after them for using it as long as they use it as it's embodied in that specific project. So that's a good way to carve out the rights that you need going forward. I think that's very important, and that's what makes the difference between some contract I downloaded off the internet versus something that's been drafted by a lawyer who's in the industry and is trying to make sure that you've got all your ducks lined up. The other thing I would say about the IP section is this. You will probably, if they hand you the contract, it will probably say everything that you do, that the developer does, is considered a work made for hire under the US copyright laws. The company owns it, blah, 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 blah. Work for hire is a very specific, what they call a term of art. It's one of those magical terms that means something very specific. And what it means is that the company is considered the author of all the copyrightable material, of the software, of everything. which matters because remember when we said as soon as you save the code, as soon as you draw the picture, you own the copyright? It's sort of a dodge in the copyright law that says if you have a contract that ahead of time in writing agrees that this is work made for hire, then we're overwriting that default rule and we're saying that the company who hired you counts as the author, even though they didn't really do it, they hired someone to do it. That has a very practical impact. And that practical impact is if you finish everything and then they're like, haha, we're not paying you, they still own the copyright because it was work made for hire. And so now you can still sue them for breach of contract. You can yell at them, you can send them threatening letters, and you may win. But you've given up a key piece of leverage because they own the copyright. They still have breached contract and you can go after them. But there's another way to structure it, which is to say, actually, everything we create is owned by us until we get the final payment. And upon us getting our final payment that's provided in this contract, we automatically agree to immediately assign all the rights and everything other than that developer tool license that I talked about. We assign everything to you. It's effectively the same thing. At the end of the day, if they're going to pay you like good clients, then they end up with the same thing. They end up with the app that they own. They never have to talk to you again. They're good. But if they were going to screw you and run away, well, now not only can you sue them for breach of contract because they agreed to pay you and you delivered, but they don't own the copyright. And you can now turn around and see, this is our little callback here. You can now go and send a cease and desist letter or a DMCA takedown notice to the App Store and say, Apple, here's a contract that states explicitly that until I'm paid, I own all this code. I wrote all this code. I was not paid. They have released this app. I did not give permission. It contains my copyrighted code. Take it down right now. Or at the very least, you can threaten to do that. Like, hey, you need to pay me in the next week or I'm going to email Apple, which is a much stronger threat than pay me because you're supposed to pay me. I mean, they're both still, in both cases, you have a strong case, but practically speaking, if they've become a flake and they don't want to pay you, they're going to be a lot more scared in the immediate sense of having their app taken down than they are of like answering letters, stringing you along, like they can string you along for 6 months saying, oh yeah, we'll pay you. Oops, we couldn't, back and forth, back and forth. So that's another good thing to do that's in your favor. They may not like it because it's definitely in your favor, but the argument is, well, if you plan on paying us, then why are you concerned about this?
Yeah, those are some early stage signals that you should be concerned about. I always like to think that if I only like to do business with honest people.
Right. So those are all the big ones. 2 tiny ones, because I know I went on forever on this. Make sure that there's a provision for attorney's fees. I know that sounds self-serving, but actually having a provision that if there's a lawsuit or a dispute, the winning party gets their attorney's fees paid. That discourages people from bullshit lawsuits. It means that people don't take you to court unless they really think they're going to win. Because if they lose, they pay your attorney's fees. So that's one of those things that goes in the end, where they list like 17 additional provisions. And the last thing, it's nice if you want to get in the IP section a carve out what I call like a portfolio license that basically says the developer is allowed to reproduce certain chunks of the work that they did just to display on their website or in their portfolio for advertising their skills. Just pre-authorizing that so that you don't have to come get permission to be like, I worked on this. Here's an example of the app I made and how great a developer I am. It's a useful thing to put that in there. So that's just another small thing. But yeah, that's my big thing. The big 4, how do you get out of it? How do you get paid? What's the scope? And how do the IP rights work?
Well, this is all amazing stuff. I'll tell you what, getting paid, of course, is a very attractive proposition.
Yes, I love getting
developers. So protecting yourself is important. I think we all get a little bit fuzzy-eyed on that, but thanks for breaking it down.
Sure.
So here's the thing. I think we're running out of time. I do want to invite you back at some point and talk more about. There's a couple other questions here, and I'm sure we'll get some more as a result of this video. So I definitely want to invite you back.
I'd be happy to come.
And I want to make a call out to the audience here at this point and say, look, Chris is a very smart guy. We've witnessed that for the past half hour or so. He's got plain language that everyone can easily understand. So, Chris, I'm going to ask you to tell everyone where they can follow you and how they can get in contact with you, and I'm going to encourage everybody to do that.
Sure. So you can either email me at chris@chrisreidlaw.com. That's Chris, REID law.com. Or on Twitter, I'm at NY Game Lawyer, like New York Game Lawyer. Email's probably better because I'm old and lame and bad at Twitter, but I will notice if you private message me on Twitter.
Okay.
You can call me 917-903-3912. I don't mind. I'm weird like that. I talk on the phone. I'm happy to chat with anyone, especially if they just want like 10 minutes free consultation to ask kind of their like dumb questions there aren't any dumb questions, but like just to get kind of a roadmap of like, here's my situation. What should I be thinking about? So don't be afraid to reach out if you think you might have a legal issue.
Okay, well, there you go. ChrisReidLaw.com. We will put a link in the show notes so that you can go over there. Definitely
recommend. Give me my terrible web design. It's due for a revision.
Well, I don't think at this point, you've given such great information. I really don't think it matters. I think everybody, it's one thing to read words on a page, but you definitely have the energy and quality of information that you've provided. I'm sold. So thanks, Chris, for being with us. Hang on after the call. I want to talk to you for a second, but for everyone watching, thanks for tuning in to another Corona Geek, and go check out ChrisReidLaw.com.